Welcome to episode 92. I'm Stuart McCullough, I'm the CEO of VHIA. And starting with this week's Industrial Roundup, and in particular with community health, which continues to progress to resolving the last outstanding agreements in this round of bargaining. A big thanks to all of our community health members who have contributed to that bargaining round. In terms of our health service members, the final Metro VHIA managers meeting for 2018 is scheduled for this week. The Metro winner of the podcast quiz will be announced at that meeting. Also, there is the final overarching reference group for 2018, which meets on the same day. There's a meeting of our payroll reference group this week, as well as a tentative statewide classification committee meeting scheduled. By tentative, I mean that the date may or may not proceed, as opposed to the state of mind of the people who attend. There is also a meeting of the mental health SDP-PWG, but as always with mental health, it's given a different name. The Health Industry OH&S Group meets on Wednesday, and our board meets for its final board meeting this Friday. As always, all of our activities are summarised through the VHIA community app. And that's it for this week's Industrial Roundup. Welcome to the weekly update, where we go in depth with a particular subject. And joining me for this week's discussion is the Manager of Workplace Relations Services and the recently appointed centre half-back for Richmond Football Club, Tim Nagle.
Thanks, Stuart. It's good to be here.
Tim, would you do the honours and reveal the clue for this week's discussion?
Sure.
All right, so I'll get you to hold it up, but I think it's for me to describe what that is.
Yes, we've turned the tables a little bit. I think it's you're doing the guessing today.
Okay, I feel very uncomfortable about this. This is possibly the dirtiest, most beaten up version of the Fair Work Act I've ever had the misfortune to see.
It is, yes. But based on this clue, based on this old beaten book, what would you say today's topic was?
I would have to say it's about electronic medical records, because there's no greater advertisement than for the shift to digital than something like that.
That's a good guess. And in fact, we may retrospectively go with that. But actually, this is the Fair Work legislation, which created the Fair Work Commission, which was the Fair Work Australia, which can be abbreviated to FWA, which means today's topic is flexible working arrangements.
On the basis of FWA?
Yes.
Wow.
We had a team come up with that.
I'm hoping they didn't spend particularly long to come up with that. Let me simply say that that is indeed a very flexible approach to the clue, Tim. So, in the words of the late, great Jack Dyer, it's deja vu all over again. That is, we've talked about flexible arrangements, flexible work arrangements before.
Yeah, so very early in the piece as well. So in episode 21, we covered the flexible working arrangements and the principles of those flexible working arrangements.
So for anyone who wants a refresher on the principles from start to finish with regards to flexible work arrangements, head to episode 21 of the podcast series, which you can find on the VHIA website.
Yeah, that's right. But today we're just going to expand on that a little bit and talk about some practical implications of fair work, flexible working arrangements, and in particular a recent case that was subject to a decision by the Fair Work Commission, and that was in relation to the matter of the Police Federation of Australia, the Victoria Police Branch, trading as the police.
Let me simply note how impressed I was that you've managed to convince yourself in terms of the FWA and Fair Work Australia bit there. Don't think that went unnoticed. But just for those members who want to get a full copy of the decision that we're going to be talking about, could you give them the case reference?
Yeah, so the case reference, I think, which we'll put up on screen, is the Police Federation of Australia, and then in brackets, Victoria Police Branch, trading as the police, 2018 Fair Work Commission 5695.
That's 5695?
5695. Ring now.
All right. And before we do a recap of that case, so before we go through that case, let's do a quick recap of the fundamental principles. What underpins the flexible working arrangements provisions?
Yeah, so the basis of this is Section 65 of the Fair Work Act. And this relates to the ability of a person to request a flexible working arrangement in certain circumstances.
And that provision is part of the National Employment Standards?
Yeah, so it is an NES matter, which means that it can't be traded away. It's a base entitlement.
And it's also part of our agreements.
Yes, so we've placed the flexible working arrangements into all of our agreements during the last EBA round. Some were already there from memory, but we've made sure that they are all there this time. And really the reason for doing that is to try and make those agreements as comprehensive as possible. There's nothing worse in terms of when you're administrating those agreements, having to go to multiple sources to try and determine entitlements. It's much better if they're in a single place.
Or not being aware that there is another source for an entitlement and that somebody knows something that you don't.
Exactly.
So let's just identify a couple of examples of flexible work arrangements.
So the Act provides, it gives examples, which is very convenient. In terms of changes in working arrangements that are subject to those requests, and they may be things like changes in hours of work, changes in patterns of work, and changes in location of work.
And remind me, what are the circumstances under which an employee is entitled to make that application?
Yeah, so they also need, so that the first test is obviously what they're requesting, but there's also circumstances that they can request that in, and there's a number of different things. So for instance, if the employee is a parent or has responsibility for the care of a child who is of school age or younger, is the first one. The second one is the employee is a carer, and that utilises the definition in the Carer Recognition Act of 2010. The third one is the employee has a disability. Fourth is that they're over 55, or 55 or over, I should say. The next one is that the employee's experienced violence from a member of the employee's family. The second last one is that they're providing care or support to a member of the employee's immediate family or a member of the employee's household who requires care or support because the member has experienced violence from the member's family, so it's an extension of the previous point. And finally, that the employee is returning to work following the birth or adoption of a child.
So for the avoidance of doubt, you need to satisfy one of those particular conditions, not all of them.
Yes,
okay.
Exactly.
And a part-time and full-time employee, they must have completed at least 12 months of continuous service with the employer immediately prior to the request?
Yeah, so that's the other caveat around that.
What about casual employees?
So in the case of a casual employee, the employee must be a long-term employee of the employer and have a reasonable expectation of continuing employment on a regular and systematic basis. So casuals are covered, but they need to get over that hurdle.
Okay, so I feel that we've covered the fundamentals. Let's move on to the decision.
Yes, the decision concerns an application by a Victorian Police detective for a flexible working arrangement.
And how did the detective qualify to make that application?
Yeah, so the basis was that they were over 55 and they had greater than a year's service, so they qualified. And the detective was seeking to work longer hours per day. So instead of working 5 days, they were looking to work 4 10-hour shifts.
So instead of 5 8-hour shifts, 4 10-hour shifts, same number of hours, fewer days, compressing the hours into a shorter working week.
Yeah, that's right, exactly.
And what were the issues that arose from that request?
So there was some unique, and there always is. Every request is different. So in this case, there were some additional considerations that the employer had. For instance, there was an expectation within that workplace that the workforce would be available to work additional hours, so overtime hours. And also there was an issue around the payment of a commuted allowance that was attracted by that different work pattern.
For that overtime, as I understand it. And so there were some complicating factors.
Yes.
And what was the result of the request?
So the police considered the request, as they're required to do, and refused it on what they said was reasonable business grounds.
Okay, so what reasons did Victoria Police give for refusing that particular request?
So they gave a number of different reasons. For instance, they said that the refusal was on the basis that they had to require them to do overtime. So if you're working less days, then it makes it more difficult to work the overtime. And they said in regards to that overtime that overtime was an inherent requirement of the role.
And look, I recall also they identified overtime as an inherent requirement, but also because of the commuted allowance, I think there was a suggestion that it meant that he'd be paid for the same hours
Yes,
twice.
exactly.
And I understand OH&S was also raised as part of that response.
Yeah, so there was concern around the longer shifts, etc. So the different shift pattern, the employer said, created an OHR fatigue risk.
And so the refusal, I take it, was then disputed by the applicant.
Yeah, so the applicant position was that wasn't reasonable business grounds to reject the application.
And it's gone through then the dispute settling procedure at the Fair Work Commission?
Yes, so it was. So the dispute settling procedure of the Fair Work Commission. Interestingly, additional grounds were identified after the fact. So it appears that that there was some additional items added, and that included the likely negative impact on that police officer's colleagues, and also in terms of parity and also productivity issues as well.
So those are interesting reasons, I think, and I think members would recognise those as a version of the setting a precedent concern, which is often expressed in the context of requests for flexible work arrangements. So what did the Commission find?
Well, they found a number of, on each of those points they made findings. So in terms of the fatigue, the Commission found that the concern lacked evidence and was therefore a neutral consideration. So it was really they've looked behind the reason stated to determine whether it was a valid reason or not, essentially.
Just want to go back to that issue of the inherent requirement argument around overtime. How did the Commission respond to that argument?
So in terms of the overtime, the Commission found that the arrangement would curtail his ability to work overtime, and it was accepted that detectives were obliged to be available to work overtime.
But as I understand it, as I recall, the Commission drew a line short of saying that it was an inherent requirement.
That's right.
And I think the words in the decision are something to the effect of that would likely be a misdescription.
Yes, I think they were suggesting it was being overstated.
You made reference to the morale issue, which we often refer to as the precedent issue. How did the Commission respond to those concerns?
So, I mean, the Commission looked at the evidence for that reason, and I think described it as thin. So
never a good start.
As soon as you start saying thin, it's never a good sign. So ultimately, the Commission didn't find that the use of the effect on others was going to be a reasonable business ground to refuse the request.
I think what's interesting for me about the decision is that it's a good example that in terms of reasonable business grounds, that they've got to be supported by evidence, they've got to be real, rather than an apprehension or a concern about precedent as such.
Yeah, I think that's the key, isn't it? It's the reasons have got to be genuine reasons.
So Tim, we've just finished another round of regional forums where the issue of flexible work arrangements came up on a pretty regular basis. And we had a lot of discussions around techniques or suggestions for effectively managing those, given that there are increasing numbers of requests being made under the NES and under agreements for those flexible work arrangements. I was just wondering if you could share with members who perhaps didn't attend one of those regional forums some of these strategies that you would suggest for managing flexible work arrangements. Yeah,
and look, I think the first place to start is to be really clear about what right the employee is seeking to exercise. So, is it a flexible working arrangement request? Is it a disclosure about some sort of disability where the Equal Opportunity Act is going to come into play? Is it a request in accordance with one of the employer's policies? Understanding where the request is originating from and therefore what the rules are, I think, is a really important first step in considering these such applications.
What I'm mindful of is that there were a flurry of disputes at a point in time where it became apparent that people making those applications didn't sometimes think about which right they were seeking to exercise and sought to exercise them all simultaneously.
Exactly, and what ended up happening is that all the parties sort of got a little bit confused about what are the considerations, what are the rules, what are our options, because they were just all being sort of blurred into one, and there was no sort of structure around how it was being dealt with. So in a lot of cases, what happened is that you actually need to go back to the start to work out, well, where are we? What's the process?
And is that what you would recommend in the event that the member is not clear as to what kind of request it has on its hands?
Yeah, and look, that might be the case because the employee might be coming from a position where they're not sure of what the entitlements are as well. So I think the number 2 tip is, if it's not clear, seek that clarity with the employee early on.
So you've made reference to the source of the entitlement. So I take it that the rules vary depending on the source of the entitlement, depending on whether we're talking about a flexible work arrangement or a process under the Equal Opportunity Act or something else.
Yeah, so I mean, if you're looking at whether an employer can make some reasonable adjustments to accommodate a disability under the Equal Opportunity Act, you're probably going to be thinking about things like, well, what's the medical information we require? What are the inherent requirements of the role? What are reasonable adjustments that can be made? That's very different to a flexible working arrangement. So with a flexible working arrangement, you're probably considering, do they meet one of the requirements in terms of their situation? And then what impact is that going to have on the workplace? And is there a reasonable business ground that we can't accommodate that?
It's interesting, the difference between reasonable business grounds as opposed to an inherent requirement kind of proposition. The other thing that strikes me, of course, is that under the Equal Opportunity Act, you don't need 12 months to qualify.
No, that's right. And also you don't have to respond within 21 days. So there's different rules. It's like playing Monopoly with the Scrabble instructions.
I have tried that. It is difficult, and best not to talk about it. So just in terms of the considerations that a flexible work arrangement should take into account, what kind of considerations would there be where you do have a flexible work arrangement request?
Yeah, I think the next point that we would make is that employees need to genuinely consider the request. And there's a couple of things to that, I think. So one is each request is going to be unique, so it needs to be treated as a unique request. So
what that says to me is that the approach of we've never done that before and we'd really like not to doesn't meet that test.
No, it's not going to meet the test, and it's not going to meet the requirements of Section 65 either. It's really about taking each request on its merits and also understanding the request. Not jumping to conclusions, not trying to import greater meaning than what's in front of you. So I think that's the next step, really understanding what the request is and leaving it to that situation to make a decision.
So you made reference before to a timeline for the consideration. There must be genuine consideration. We've already established that you need some evidence to reach your conclusion in terms of reasonable business grounds. But just talk to that time frame.
So the Act there's a statutory requirement in the Act to do with that within 21 days. So that becomes a consideration in terms of the process that you map out. And seeking clarity as soon as possible is going to be the key.
So that's really about engagement.
Yes.
And so the police case might be a good example where there might have been an opportunity for the parties to consider things a bit further before responding or engage a bit further. And
I think the key item there is that the request might be for instance, to get over a particular issue. But there may be a range of options open to the employer and the employee to agree to, because at the end of the day, it's an agreement, it's an arrangement that both parties can agree to. So it may be, for instance, often a request not to do night shift might be what the request is based on for whatever reason. It may be that for that ward that it's not possible, and there might be really genuine good reasons for that. But it may be possible in another ward, you know what I mean? So it may be that the outcome or what's agreed to isn't contemplated by either party at the start, but through discussion and through exploring it, a solution that suits both parties can be found.
So you're saying that both parties should come to a discussion about a flexible work arrangement with a flexible frame of mind.
That's right.
If there is an agreement, what else is important?
So I think if there is an agreement, then it's important, obviously, that there's a requirement to have it written down, so reduced to writing. And I think being absolutely clear about what that agreement is in that in that written record is really important. There's nothing worse where there's a requirement to put it in writing and then both parties turn around 6 months later and don't know what it means. So I think being really clear is really important with that record of it. The other thing that's really important is contemplating a review date. So often what happens, no workplace will stay the same and things change. So I think it's important that flexible working arrangements also have that capacity to change over time. So, you know, whatever that date is, whether it's 6 months, whether it's 3 months, 9 months, 12 months, it's important that it gets revisited and rediscussed.
So that's sort of a structured approach to revisiting. Is it possible also to say that, look, the employer may seek to consult and change?
Yeah, so I think so it may be that the what's in control of the parties changes. What's not in control of the parties changes. For example, there may be a trigger outside those two that leads to the flexible working arrangement needing to be reviewed.
So you could reserve that right to revisit it if the circumstances require it?
I think so. So if you had a circumstance where the workforce within a particular area, there was only a request for a single flexible working arrangement, but you know, down the track there was 10 requests. So I think that would be a trigger for the parties to say, well, we need to revisit this.
It raises some really interesting equity issues. That if that a basis for refusing shouldn't be that somebody else got there first and therefore no one else can be accommodated.
Yeah, that's right. And it's the other side of the coin of saying, well, no, I'm not going to because what if everyone does? This actually overcomes that because it says, well, we're going to agree to, because there's no other reason not to agree to it, but there may be a trigger down the track.
Look, we certainly have in regard for that time frame. If members are unsure how to engage with a request for a flexible work arrangement, what would you recommend?
Well, so I think that seeking support obviously is the best approach. Thinking through it, working through it, but if you do need some assistance, either contacting our HR department or contacting us, or seeking some additional assistance to try and work through the process and through some of the considerations. We know that there's material out there also to help. The Ombudsman, I think, has got some material to help. We're going to put some material together also to assist. It's about trying to access that additional information and support material.
Terrific. Well, thank you so much for this update with regards to the progress for flexible work arrangements.
Thanks, Stuart.
Thank you, Tim.